Probate, the legal process of settling a loved one's final affairs, is already stressful enough during a time of grief. It's a maze of paperwork and deadlines. But what happens when heirs and family members, already under emotional strain, don't agree on the path forward? Disagreements can erupt over almost anything. One child wants to keep the family home for sentimental reasons, while another insists it must be sold. A sibling might challenge the validity of the will, claiming a parent was unduly influenced when they wrote it. Other disputes can arise over who gets specific personal items, or even how the personal representative is managing the estate, with accusations of unfairness. Suddenly, what was supposed to be a process of honoring a loved one's wishes devolves into a painful family battle. The estate's assets, meant for the beneficiaries, start getting drained by mounting legal fees, and the entire process can be delayed for months or even years. Thankfully, there is a better way. In Florida, the legal system strongly encourages a solution called probate mediation. It's a structured, confidential process where a neutral mediator helps the family negotiate their own agreement. This is designed to resolve conflicts efficiently, saving everyone the emotional and financial drain of a long court battle, and putting control back into the hands of the family. Today on Clear Probate, we're going to cover why probate disputes arise in the first place, what mediation actually is, when Florida probate courts require it, step by step, how the mediation process works, common issues families resolve in mediation, real-world case studies, and tips to make mediation successful. By the end of this video, you'll have a clear roadmap. You'll understand how probate mediation works, what to expect, and how it can be a powerful tool to save time, money, and most importantly, the family relationships that matter most. Probate disputes aren't just about money. They're often fueled by a complex mix of raw emotions, cherished memories, and deeply held expectations. During a time of grief, old family rivalries or perceived slights can suddenly resurface, turning a difficult time into a legal battle. Common reasons families disagree include unequal distributions. One heir feels another got more, especially if that sibling was a primary caregiver and feels their sacrifice wasn't acknowledged in the will. Valuable property. A family home or heirloom sparks disagreements when one person wants to keep it for sentimental reasons, while another wants to sell. Executor choices. Heirs may mistrust the personal representative, questioning their transparency, fairness, or competence in managing the estate. Creditor claims. Heirs dispute which debts should be paid from the estate, as this reduces their inheritance. And finally, will challenges, where someone questions the document's validity, claiming things like undue influence or lack of capacity. Consider a Miami case where 3 siblings fought over their mother's jewelry. The will wasn't specific, and each wanted pieces with sentimental value. A costly court trial loomed, which would have depleted the estate. Instead, they chose mediation. A neutral facilitator helped them communicate and devise a creative solution where they took turns choosing items. This preserved not only the assets, but, more importantly, their family relationship. This highlights a common dilemma. If you were left a family heirloom, would sentimental value or financial value matter more? Share your answer in the comments. Mediation is a confidential process where a neutral third party, the mediator, helps families resolve disputes. Key points about probate mediation in Florida. It's non-binding unless an agreement is reached. The mediator doesn't decide, they guide discussion. Everything discussed is confidential and can't be used in court if mediation fails. Agreements reached are written, signed, and enforceable. In Orlando, heirs disagreed about whether to sell their father's rental property. Through mediation, they agreed to keep it and split rental income, a solution no judge could have imposed. In Florida, courts often require mediation before scheduling full probate litigation. Judges know mediation saves time and court resources. Mediation is usually required when there's a will contest, heirs dispute how assets are divided, beneficiaries object to an executor's actions, large debts or creditor claims are contested. Sometimes families request mediation voluntarily, even if not ordered. This can help prevent a fight from escalating. Here's what to expect if you enter probate mediation in Florida. Step 1. Select mediator. Courts may assign or let the family choose a certified mediator. Step 2. Pre-mediation prep. Each side submits a confidential summary of issues. Step 3. Opening session. Mediator explains the rules. Confidentiality, respect, and voluntary participation. Step 4. Discussion. Each party explains their perspective. Mediator keeps conversation balanced. Step 5. Private caucus. Mediator may meet separately with each party to explore options. Step 6. Negotiation. Mediator guides parties toward compromise. Step 7. Agreement. If reached, the agreement is written, signed, and enforceable by the court. Mediation can resolve nearly any probate conflict. Common examples: real estate decisions, sell, keep, or rent; personal property division, jewelry, furniture, heirlooms; executor performance, whether they're doing their job properly; creditor claims, which debts to pay and how; disputes over will validity. Even if not resolved fully, compromises are often reached. A family in Jacksonville couldn't agree on whether to sell their mother's beachfront condo. Through mediation, they agreed one sibling could buy out the others at appraised value. Everyone walked away satisfied. Case 1. Jewelry dispute. 3 sisters fought over their mother's jewelry. Mediation allowed them to rotate items, each keeping something meaningful. Case 2. Business ownership. In Tampa, heirs fought over a family business. Mediation created a plan where 2 heirs sold their shares to the third. Case 3. Will contest. In Naples, one heir claimed undue influence. Mediation didn't solve everything but reached a compromise. Heirs agreed to split assets differently than the will stated, avoiding a full trial. Why mediation is often better than trial. Saves time. Trials add a year or more. Saves money. Mediation costs far less than litigation. Keeps privacy. Mediation is confidential, unlike public trials. Preserves relationships. Mediation encourages compromise instead of hostility. In Fort Lauderdale, mediation settled a dispute in one day that could have taken a year in court. The estate saved thousands in legal fees. Come prepared, bring documents, appraisals, and facts. Stay open-minded. Compromise is key. Focus on interests, not just positions. Why does each heir want what they want? Be respectful. Emotions run high, but civility helps. Work with professionals. Attorneys and mediators guide you. If you were in mediation, would you prefer compromise quickly or hold out longer for your ideal outcome? Share your view in the comments. When families don't agree, the probate process can feel overwhelming, with the stress and public nature of a court battle taking a heavy toll. But Florida probate mediation offers a powerful alternative. It gives families a private, structured chance to resolve conflicts fairly, avoiding the immense time, cost, and emotional pain of a full trial. So as a quick recap, remember these key points. First, the entire process is confidential, creating a safe space for honest conversation. It's guided by a neutral mediator whose only goal is to help you find common ground. Second, it's a process the courts themselves endorse. In fact, many Florida judges require families to attempt mediation before a case can go to trial. Third, it's versatile enough to resolve a wide range of issues, from who gets the family home to challenges over executor performance. For example, you could agree for one sibling to buy out another, an option a court might not offer. And most importantly, where litigation creates winners and losers, mediation encourages collaboration, helping to preserve vital family relationships. We created Clear Probate to empower you with knowledge. If this guide was helpful, please subscribe and join our community. We're constantly releasing new videos designed to bring you clarity and peace of mind. Now we want to hear from you. What's your biggest question about mediation? Or what's one piece of advice you'd give another family? Share your thoughts in the comments below. We read every single one, and your story could make a real difference to someone else.